2 days ago, the UK Home Office released a publication to Home Office workers on how they should handle the casework for those applying for dependent visa on those who are currently on the work visa. And this cut across those on the skilled worker visa, the health and care visa. So going forward, how every caseworker should handle the application. And the reason why this is important because it helps us to really understand how future applications of dependents of health and care visa worker application is going to be handled, what to expect, the requirements you need to meet, and that's all I'll be sharing with you guys in this video. And there's so many information around going about how dependent visa is going to be massively affected going forward. However, there's some exception stated on the Home Office publication sent out on the 11th of March 2024. So all of this information that I'll be sharing with you guys in this video, and also to keep you guys updated on what exactly is happening for those who are looking at applying for the health and care visa going forward, or those who have been on that visa, those who will be applying, among many others. So guys, if this sounds like something you'd like to know, or someone who should be aware of this information, then please do watch this video to the end and share to as many people as you can. And if you're coming across my channel for the first time, please do well to hit the subscribe button to join the amazing growing family. And my returning subscribers, thank you guys for being here. I really do appreciate you guys. So without further ado, let's get right into the video. There has been a lot of concerns being raised by different individuals in the UK about their different individual conditions and how the new policies around the dependent visa is going to affect them and their family. And the interesting thing is that the new publication sent out by the Home Office actually addresses different scenarios, which I'll be sharing with you guys in this video. So if you're currently in the UK on the health and care visa, or you're about to get your COS for your health and care visa application, then you definitely want to sit and watch this video until the very end. So this is some information sent across. So this particular publication was sent to caseworkers, those who handles applications for UK immigration and visas, and the information just will help them further check out the application they receive and make sure they're approving or rejecting according to law. Now, this is going to be solely on those who are currently on who are planning to get the care worker visa from this period when the video is made. We've gone past 11th of March, and from now, those on the health and care visa, or those who are going to get their health and care visa approved now, will no longer be able to bring in their dependent. However, there's some exceptions and some scenarios I'm going to be sharing with you guys in this video. So the first thing is that unless one of the exemptions below apply, which I'm going to talk about the exceptions, the applicant must not be applying as a partner or child of a skilled worker who is sponsored for a job in the occupation code 6145, that's care workers and home carers, or 6146 for senior care worker. Now, emphasis on partner or child. So it means that one of the questions I got asked in my previous videos is, what happens to children? This answer is, the children are not allowed to apply. However, I remember they said that unless one of the exemptions below apply, we're going to look at this exemption shortly. So it means that if you're getting that visa based on the occupation code 6145 and 6146, your partner and your children must not apply with you on the visa. Now, it went further to now say that if the lead applicant has continuously had permission on a skilled worker, accepting that any gap subject to paragraph 39E can be disregarded under the rule in force before 11th March 2024, sponsored in either or both this occupation code 6145 or 6146, a dependent may apply. To be eligible for this exemption, the lead applicant's original application date must have been before 11th of March 2024, even if the application was granted after 11th March, and whether or not their dependent apply at the same time. If the dependent is a child who is born in the UK, the child can apply. Now, this answers one of the major questions I've probably given an answer to in my previous videos. And the question is, what if I apply before 11th of March and I haven't gotten a decision? The answer is that even if you get a decision end of March or early April, your partner and your children can still apply for the dependent visa. However, if your application date falls on the 11th of March and after, your partner or your children are not eligible to apply for the dependent visa. So now, amidst all of this information, there are different scenarios that the UK Home Office has painted and given answers to whosoever personal or individual condition or situation falls under these examples. Now, they're talking about migrant 1 or migrant A has been sponsored on a care worker with their partner and child since 10th of January 2022. Their dependent can continue to apply as such. So if you've been on the health and care visa before now, your partner and children can continue to apply with you. Now, migrant B has been sponsored as a care worker since 25th of November 2023, but had not applied for their partner or children. They can make an application for their dependent to join them at any time during their period of leave. So it means that if you've been on the health and care visa for a while now, but you haven't brought in your partner or children, or you're about to get married, or you're about to bring in your partner on that visa, the partner can apply for that visa as long as you're still on that health and care visa. Now, migrant C has been sponsored as a nursing auxiliary since 10th of July 2023, but switched to being a senior care worker with an application date on the 15th of March 2024. Their dependent will not be allowed to make applications in connection with their leave as a senior care worker. So this is to tell you that if you're on a different visa category and you're switching to a new visa as a care worker with the shortage occupation code 6145 or 6146, your partner and children are not eligible to apply. And this same applies to international students also. Those who are on the student visa looking to switch to the health and care visa. The moment you switch to the health and care visa, your partner, your children, your dependents are not eligible to apply for the dependent visa on the health and care visa while you are the lead applicant. And that scenario, migrant D has been a student since 1st of September 2021, then switched to being a carer, have completed their studies with an application made 1st of January. The dependent will not be allowed to make application in connection to their leave as a care worker. So I've explained this already. So for students looking to get a skilled worker visa, if you're married, if you've got family, then don't even go ahead to get that serious from your employer, because your children and your wife will not be able to apply for the dependent visa. Another scenario, the migrant E has been sponsored as a care worker since 1st of June 2023, but switched to being a senior carer with an application made 25th of March 2024. The dependent can still make application. So far, you've been on the health and care visa, you've been on the job with that same shortage occupation code. If you're switching employer, your partner and your children can still apply for the dependent visa. Then lastly, the last scenario situation, migrant F switched from being a dependent partner of a student to being a senior carer with an application made on the 10th of March. Their partner can apply as a dependent subject to course completion. Now, look at the condition. Made the application on the 10th of March. That's before 11th of March. So if you're dependent, if you're a student and your dependent decide to get the health and care visa before 11th of March, by the time you're done with your program later in the year, you can apply for the dependent. However, if your dependent apply for the health and care visa after 11th of March, by the time you are done with your program, you cannot apply for the dependent visa under your partner, which is really sad, but really that's just the situation of things. Now, children who are 18 or older on the date of application who have not previously been granted permission as a dependent of the lead applicant cannot be granted permission as a dependent child. Similarly, other relatives, for example, parents or grandparents, cannot apply. So this is an important information you need to know. Now the question now is, what is the exceptional dependent application? There's an exception to all of these rules. Now the question is, what is the exception on these rules? Now the exception for dependent application is that when there are exceptional, compelling and compassionate circumstances raised on behalf of a dependent who cannot meet the requirement to be granted entry, clearance, permission or settlement as a partner or child of a lead applicant, you must consider the application outside the immigration rule. So it means that if there's a reason, a reason, and is it a situation you might actually need the service of a solicitor, an immigration solicitor, immigration lawyer to help in the situation. So if there's a situation whereby your dependents actually don't meet the requirements and there's a compelling reason why their circumstances doesn't warrant them to, then this particular situation must be treated outside the immigration route. That's the exception. So yeah, so if your partner gets a care worker visa and the other partner also get a care worker visa, the children cannot remain in the country without any visa. It's going to affect their future application for the indefinite leave to remain and subsequently their British citizen application. So you need to get in contact with an immigration lawyer to help manage that situation and get a proper legal advice if you are in that particular situation. So if you have any further questions around these policies, please state in the comment section. And if you're coming across this channel for the first time, do well to hit the subscribe button below to join the amazing growing family. And to my returning subscribers, you guys are the real MVP. Thank you for being here. I really do appreciate you guys. So this will be the end of this video, and I'll see you guys in my next video. Thank you.